Everyone is suing Logan Paul, which is weird because he seemed like he took legal obligations so seriously.
I had to rely on my team. I crumbled internally.
But things aren't looking great for Logan Paul or his Prime energy drink company. Dramatically declining sales are only the tip of the iceberg and have caused him to be sued by not just the US Olympic Committee, but also the manufacturer of the drink. As many YouTubers have found out, your fans can propel you to huge success on the streaming service, but selling products away from YouTube is about much more than a hungry fan base. And if you don't cross your legal T's and dot your legal I's, you could be in a lot of hot water. And that's where Logan Paul finds himself today, thanks to 2 lawsuits that may sink his popular beverage brand. The US Olympic Committee is suing Paul for trademark infringement, and Prime's manufacturer said that Paul breached their contract when sales of the drinks started to tank. So today we'll be breaking down those 2 lawsuits. Now, Logan Paul has a knack for making quick money, scamming people, and getting punched in the face. And our last video about Paul covered his bonus defamation lawsuit against CoffeeZilla. Now, fighting this lawsuit is costly, and you can check out CoffeeZilla's video on how you can help. But the current dust-up is about Paul's beverage line, Prime, which launched with influencer KSI back in 2022.
We made a better-for-you drink that tastes better.
Yeah. Prime currently has 2 offerings, Prime Hydration, which doesn't have caffeine, and Prime Energy, which does. A 12-ounce bottle of Prime Energy has about 200 milligrams of caffeine, which is the equivalent of about 6 cans of Coke. Now, demand for both products was initially through the roof. People lined up at dawn to get the new flavors, bottles were sold out on eBay for thousands of dollars, and people literally fought each other to get their hands on the orange mango flavor. And of course, both Logan Paul and KSI have been involved in various controversies over the years, from problematic content on YouTube to highly publicized personal feuds. These controversies have spilled over into their business ventures, including lawsuits and inquiries by several US states and many more European countries. Basically, wherever Prime's beverages have appeared, they've also been the target of the law. For example, Canadian and New Zealand regulators banned Prime Energy because it exceeds their regulatory limits for caffeine. But in the US, there is no legal limit for the amount of caffeine the companies can put into their energy drinks. And thank goodness for that, America. But we discussed high caffeine levels in the video that we did on Panera Bread's Charged Lemonade. And when the same concerns were raised about Prime, Senator Chuck Schumer asked the FDA to investigate Prime Energy. And in April, consumers filed a class action lawsuit accusing Prime of mislabeling the amount of caffeine in each drink. Though Prime says its energy drink has a warning label that it is not recommended for children under 18, and that it contains comparable level of caffeine to other competitors. Now, obviously, if you're getting sued by the notoriously litigious US Olympic Committee, you want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car or trucking crash, suffered a data breach, especially if you got a letter saying that your social security number might have been hacked, or are dealing with a sexual harassment suit, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can maximize your recovery and find out what your options are. So just click on the link in the description or call the phone number that's on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So you can click below. But Paul and KSI are now facing 2 additional lawsuits that show how sloppy Prime is at business. In a complaint filed on July 29th in Federal District Court of Colorado, the U.S. Olympic and Paralympic Committee, or USOPC, sued Prime for the unlawful use of Olympic trademarks. The complaint alleges that Prime, quote, in a deliberate and willful attempt to trade on the USOPC intellectual property, used Olympic-related terminology and trademarks in marketing its products on internet advertising and in promotions for a Prime hydration flavor featuring Kevin Durant. The infringed trademarks include Olympic, Olympian, Team USA, and Going for Gold. Now, I first heard about this lawsuit from Legal Bites, who made a video explaining why Prime was in legal trouble. This lawsuit came out when there was a lot going on in the world, and I was focused on other things. But you should really check out the video. She does a good job of explaining U.S. trademark law, including why an official Team USA merchandise licensee has significant value to brands. As you probably know, a trademark can be any word, phrase, symbol, design, or combination of these things that identifies goods or services. The purpose of U.S. trademark law is to allow consumers to easily identify producers of goods and services and avoid confusion. And because of that, a trademark can last indefinitely so long as the user is using it in commerce. Unlike copyright or patent law, which eventually expires. Now, with respect to the Olympic Games, for decades, brands have known that when consumers see a product with the words Team USA or the image of a popular athlete, they are more willing to buy it. And so if a company wants in on US Olympic glory, it has to become a licensee of the USOPC. And the USOPC gets to decide who can use those trademarks and where they appear. So for example, if you see a Wheaties box featuring Katie Ledecky or Simone Biles with the words Go for the Gold, that's because Wheaties paid for a license. And lots of companies work with the USOPC, such as Coca-Cola, Polo, Eli Lilly, Cisco, Warner Brothers, Delta, Fanatics, and Visa. And of course, Prime is not on that list because it never negotiated a license. However, the label on the bottle of Prime's Kevin Durant-themed hydration drink features Durant's name emblazoned above a curiously patriotic-looking Prime logo. The bottle also talks up Durant as the 3x Olympic gold medalist and counting. The text says when Katie steps on the court, he's going for gold. And the complete features lots of ads that Prime Hydration placed on social media and on its official website, as well as advertisements on various social media platforms and physical printouts for stores selling the drink. For example, quote, Prime Hydration provided ad copy to stores selling the infringing product that prominently used the Olympic marks, using the word Olympic 6 times in ad copy, including 2 uses of Kevin Durant Olympic Prime drink. Celebrate greatness with the Kevin Durant Olympic Prime drink, Olympic achievements, Kevin Durant Olympic legacy, and other uses. Now, I found this to be fascinating because not only does the USOPC have the rights to the trademark by right of trademark law, but they actually got it written into law. 36 U.S. Code 220506 grants the U.S. Olympic Committee exclusive rights to the name, seals, emblems, badges, all of that associated with the Olympics, including the name, the United States Olympic and Paralympic Committee, and the symbol of the International Olympic Committee, as well as related words and phrases, including Olympics, Olympiad, and Paralympic. And the law says that the Olympic Committee can bring a civil lawsuit under the Trademark Act of 1946 against a person who, without the committee's consent, uses the Olympics-related symbols, emblems, and words mentioned earlier for the purpose of trade to induce the sale of any goods or services, or to promote any theatrical exhibition, athletic performance, or competition. Now, the law does include some exceptions from civil suit, mostly to do with place names and regions with variants of Olympic in the name, such as Olympia, Washington, but unfortunately for Prime, they aren't one of the exceptions. And the second claim for relief is a regular trademark infringement claim under the Lanham Act. The complaint alleges that Prime's use of the Olympic trademarks is likely to cause confusion, mistake, or deception about the source of its products, thus infringing on the USOPC's trademark rights. And in the U.S. courts evaluate a claim for trademark infringement primarily by analyzing whether there is a likelihood of confusion between the plaintiffs and defendants' marks. And most courts use some combination of the factors set forth in the case of Polaroid versus Polarat Electrics. These include the strength of the senior user's mark, the similarity of the two marks, the similarity of the products or services, the junior user's intent in adopting the mark, and the sophistication of the buyers. And courts will also consider evidence of actual confusion by consumers. And another issue is whether there's similarity of the goods. And here the USOPC is right that its mark is frequently used on similar goods. Powerade is the official sports drink of Team USA, and Prime is its direct competitor. The USOPC sent a cease and desist letter on July 10th, but it alleges that Prime continued to ship products and use the marks on social media. The company continued to feature both the bottle and copy on LinkedIn, making it look like it deliberately wanted to use the goodwill associated with Team USA to promote its own products and brand. There's a third claim for unfair competition and false designation of origin in violation of 15 U.S.C. 1125. And there's a fourth claim for trademark dilution. Now that's interesting because dilution occurs when a third party uses a mark or trade name in commerce that is sufficiently similar to a famous mark such that it harms consumer perception of the famous mark. The complaint says that, quote, the USOPC has used the famous Olympic trademark in interstate commerce since at least as early as 1896, which is prior to the use by defendant. It notes that, quote, the Olympic marks have been used in commerce by the USOPC for decades, and billions of viewers around the globe are expected to tune in to the games this summer. Prime Hydration's use will dilute the distinctive quality of the famous Olympic marks under Section 43 of the Lanham Act and injure the USOPC. And the courts have given the USOPC even stronger protection for its trademarks than it would have under a normal trademark claim under the Lanham Act. In San Francisco Arts and Athletic Inc. versus United States Olympic Committee, the Supreme Court barred the San Francisco Arts and Athletics Company from using the words Olympic in its gay Olympic Games. The court held that the committee had the exclusive rights to the word Olympic under the Amateur Sports Act of 1978, and could prohibit its use without needing to prove trademark infringement or consumer confusion, which you would normally need to do under a trademark action. The court ruled that this exclusive right was constitutional and did not violate the First Amendment because the committee's use of the words served a legitimate purpose and its protection did not unfairly restrict free speech. And courts interpret 36 U.S.C. 380 broadly. It gives the committee the sole power to use the International Olympic Committee. It gives the committee the sole power to use the International Olympic logo consisting of 5 interlocking rings. For example, in USOC versus Interlicense Corp., the committee sued a marketing firm for publishing pictograms using the Olympic rings mark. Quote, the pictograms at issue are graphic designs of athletes participating in various summer and winter Olympic sports against a backdrop that explicitly incorporates the Olympic symbol consisting of 5 interlocking rings. The International Olympic Committee had given the firm permission to use the rings, but the Second Circuit Court of Appeals said that that was not enough. Interlicense needed the USOPC's permission to use the rings in the United States. And some argue that the USOPC takes this protection to the extreme. For example, in 2005, the committee threatened to sue the Improv Olympic Theater if it did not change its name. The Improv Olympic Theater helped launch the careers of Stephen Colbert, Seth Meyers, and Bob Odenkirk, among others. And the group had been using the name for 20 years, but it changed its name to IO to avoid the lawsuit. But Logan Paul might have some exceptions. There is an exception to U.S. trademark law known as nominative fair use that may help Prime. Nominative fair use permits the use of another's mark to refer to the trademark owner's goods and services associated with that mark. This is permissible as long as the use is necessary to identify the product or service, the use is limited to what is needed to make the identification clear, and the use suggests that the trademark owner endorses or is affiliated with a user. The nominative fair use doctrine was created in a case that involved the New Kids on the Block versus two newspapers that ran polls gauging the band's popularity. The court ruled that the use of the band's name did not violate the trademark because it was necessary to identify the band and did not suggest sponsorship. So hypothetically, Coca-Cola could say it's better than Pepsi, even though Pepsi is trademarked, because there's really no other way to identify the product other than calling it Pepsi. For example, in Playboy Enterprises versus Wells, the Ninth Circuit ruled that Terry Wells' use of the term Playboy and Playmate on her website was nominative fair use because it accurately described her former status and did not imply Playboy's sponsorship or endorsement. The court held that Wells was allowed to mention the name Playboy and use the related terms like Playmate of the Year or PMOY, but she couldn't use Playboy's most distinctive mark, the Playboy Bunny. So you can see how that might apply here. First, we look at whether the trademark is necessary to identify the product or service. And in fact, this often comes up when you're talking about the Super Bowl. And for various reasons, people have come up with some very creative ways of describing the Super Bowl. But for example, the Pittsburgh Steelers have won 6 Super Bowls. If you wanted to describe this level of success, you couldn't really get your point across without saying the phrase Super Bowl, even though that's trademarked. It would be strange to say the Steelers won 6 really big games. The second factor is whether you're using as much of the trademark as necessary. So in that context, the phrase Super Bowl, which is a trademark, is probably okay, but your use of the Super Bowl logos, that's probably a step too far. So similarly, Prime is probably free to say that Durant won 3 gold medals, but the company probably can't use the Olympic rings. And the third factor is that you can't create the impression that you're affiliated or endorsed by the user. And that's where the USOPC has gotten very aggressive, and they will police any suggestion that a company or person is formally affiliated with the US Olympic team because it's trying to protect the value of the sponsorship that it sells. But here, the Wells decision might actually help Prime argue that it had a right, with Durant's permission, to describe him as an Olympic champion and a gold medal winner. If you take a look at the bottle, it doesn't seem to use the font favored by the USPC, and Durant isn't featured on the bottle wearing his Team USA uniform, and there's no other indications that the Olympic Committee is partnering with Prime. And so the USOPC is seeking all the profits associated with the sale of Prime, which the committee claims is in the millions of dollars. It also wants damages for harm imposed on its sponsorship agreements with its licensees. But Prime has yet to respond to the lawsuit, possibly because it's busy fighting another major lawsuit, which is about the lack of success of Prime. It's really getting whipsawed here. In November of 2023, Bloomberg concluded that Prime was on track to make over $1.2 billion in sales. Prime and its branding company Congo were bullish on the company's future. With supply outstripping demand, the company looked for a manufacturer that could handle the large orders. So they turned to Refresco, a beverage manufacturer that produces products for various brands and retailers. And in 2022 and early 2023, Refresco acted as the bottler for Prime, but only on a spot basis, meaning that they would only accept irregular orders on demand. However, this arrangement was costly because it required Refresco to purchase from third parties unfilled bottles that had been fabricated for Prime's unique design and trade dress, including the shape and size, because specialized molds and related equipment are needed to fabricate those bottles. And in early 2023, Prime wanted to lower its production costs by limiting the deals with third-party bottle suppliers. So Refresco allegedly informed Prime that a production line in its Truesdale, Missouri factory had become available. And to produce its products, Refresco would need to refit a dedicated line with new equipment, including some that would be custom-made to accommodate defendants' bottles. According to Refresco, in the normal course of business, customers pay for or finance the cost of ordering all that equipment, but Prime and Congo were not willing to reimburse Refresco for the dedicated line. Allegedly, since Refresco would be unable to use that line for any other customer, the company asked Prime to minimize its risk by agreeing to minimum orders for 3 years. Prime allegedly agreed to order a minimum of 18.5 million cases, or 222 million bottles, for a total of 55.5 million cases cumulatively over the 3 years. And apparently there was also a take-it-or-pay-it arrangement. Quote, if defendants did not purchase and take delivery of at least 90% of the agreed annual volume commitment for each of the 3 contract years, defendants would be obligated to pay Refresco a fixed shortfall amount for each 12-bottle case below the volume commitment that defendants did not purchase. The parties called this contract the Truesdale Agreement. And since demand was so high at the time, Prime told Refresco that they anticipated needing, quote, spot contracts for production from other Refresco facilities from time to time. So the parties also worked toward a master supply agreement, or MSA, to facilitate future spot contracts for Prime products in other Refresco facilities. So the Truesdale Agreement was signed on April 3rd, 2023, and Refresco immediately ordered customized equipment from third-party manufacturers in Europe. The agreement contained a provisional deadline for starting production on the dedicated line, and the last line says that the provisional deadline could be changed as agreed by the parties. And Refresco alleges that on June 12, 2023, the parties changed the deadline for the dedicated line. The changes were apparently discussed in a phone call and then memorialized on a spreadsheet, which said, quote, the dedicated line in Truesdale would be ready for startup in March-April 2024. The revised date was necessary because the European manufacturer of the equipment needed more time. So in this exchange, you can see how business relationships can gradually break down. Refresco says an email attachment contained a new date for commencement of the dedicated line, but Prime did not respond with a clear message that it agreed to the new deadline. Refresco continued to make plans for the dedicated line, but Prime seemingly did not object. And the agreement obligated the parties to keep working on the MSA, which was supposed to be done by October 1st, 2023, but Prime didn't give feedback on the MSA until the deadline passed. And by the spring of 2024, the dedicated line was just about ready for production, but when Refresco told the defendants that they needed to know Prime's orders for April and May, the Prime defendants said that they would have an estimate by the end of the day, quote, but they did not provide the requested forecast that day or ever. And after 3 weeks of silence, Prime's manager of external manufacturing told Refresco that, quote, the decision was made to not move forward with the incubation or flavor qualification at Truesdale. That is a roundabout way of saying that the deal is dead. Sorry, not sorry about the new dedicated line. Now, Refresco says that the reason Prime canceled the deal is because it realized that a slowdown in sales of their Prime hydration products likely was not just seasonal, that those sales, which had slowed in early winter, were not picking up as spring approached, as defendants had expected. Prime claimed that the Truesdale agreement expired on its own terms because the parties couldn't come to terms on the master supply agreement. That would be a fairly weak explanation, since the main reason for the business relationship was to get a dedicated line that would allow for Refresco to fill massive orders. The more likely scenario is that Prime decided not to perform on its obligations because sales of Prime dramatically slowed down. So Refresco sued for breach of contract, promissory estoppel, and equitable estoppel. Refresco argues that the Truesdale agreement was binding on the parties as of April 3rd, 2023, and that it fully performed on its obligations under the contract, and Refresco says it sustained damages in the amount of $67 million. Now, the $67 million damages request is pretty interesting because now yet a third company claims that Prime can't pay its bills. Agrovana is a Massachusetts-based importer, which says it has provided over $70 million, surprisingly close to the $67 million, worth of ingredients to Prime since 2020. Agrovana says it has a contract with Prime for more than $32 million of product for the first half of 2024, but Prime stopped paying its bills and eventually refused to accept deliveries. But Prime contends that the products were defective. In the complaint, Agrovana alleges that Prime failed to pay for products and used, quote, deceptive acts and practices to avoid paying for products it had ordered in binding purchase agreements. And in a story you've probably heard before, the company blames Prime's, quote, inability to sell their product at the rate they projected for the alleged breach of contract. So don't be surprised if Logan Paul tries to flee the country, and if he does, he'll definitely need a good data plan to upload his videos while he's on the lam, which he can do with today's sponsor, Saley. Because Saley is an incredible new eSIM service app from Nord Security. Because if you've ever been lost abroad or badly needed an internet connection with no Wi-Fi in sight, you'll understand what a difference a local SIM card can make. I'd never travel without one. Because an eSIM provides an internet connection wherever you travel and saves you a ton of money on roaming fees. And you can buy the data you want. Saley lets you choose from multiple affordable eSIM plans in over 150 countries. You can get tons of data and never have to worry about your tourist photos uploading in the background eating up all of your data. Not that that's ever happened to me. But I recently traveled to Japan, as you may know if you watched my reaction to Ace Attorney with a real Japanese lawyer. I was in Japan for 2 weeks, and getting an eSIM was the best decision I ever made. If you've ever tried to use the Tokyo subway without Google Maps, you know how important it is to have good internet service. And while all my friends were dealing with roaming fees and having their cellular data throttled, I could still navigate and plan daily activities while using ultra-fast internet wherever I went. I could even use my phone as a hotspot. Plus, with the Saley app, getting an eSIM couldn't be simpler. You just buy a plan and activate it, all on the Saley app or website. And once you've got it activated, you're good to use the internet wherever you go without needing to pop into a cafe and pray they have Wi-Fi. And of course, no waiting for a physical SIM card or having to switch one out. And all Saley eSIM plans are compatible with iOS and Android devices. And of course, an eSIM with Saley means there's no need to wait in line at a local airport to get a local SIM, and an eSIM can be installed only once, eliminating the need for users to install a new eSIM for each country. So you're covered virtually wherever you're going. So click on the link below or use the code LegalEagle to get an exclusive 50% off your first purchase. A Saley eSIM really is a traveler's best friend, and it's the best decision you can make before going to another country. So click on the link below or the one that's on screen right now to get 15% off. After that, click on this link over here for more LegalEagle, or I'll see you in court.